and to answer that question, and he said, I would need to know more facts, it simply means that there is a set of facts under which John Yoo and the memos he wrote and the advice he gave and the conduct he engaged in would tolerate each one of those forms of outright torture. Now, the torture debate, to some extent, is too narrow. Domestic law and international law provides that it is not only torture that is prohibited, but cruel, inhumane, and degrading treatment. And the gross malpractice that John Yoo committed in writing his memos was to ignore existing law. A simple first-year law student would have gotten an F on the memos John Yoo wrote. Because when John Yoo came to talk about presidential power in time of war, he didn't cite the Youngstown Steel case when Harry Truman tried to seize the steel mills to press them into service in the Korean War, and the United States Supreme Court said, no, you don't have that power. And in a careful opinion, the Supreme Court defined the standards under which a president may act, and the least power he had is when Congress has already occupied the field, and Congress has occupied the field in enacting the torture statute and in domesticating the Geneva Conventions and international treaties and conventions against torture. And this man, who calls himself a lawyer, didn't even cite the key case when it came to his analysis of presidential power. When he was shopping around for a convenient definition of torture, he went to a health law that set this extraordinary standard for pain and suffering equaling organ failure or death. That was the narrow definition that John Yoo served up to the CIA to give them legal cover for what they were about to launch in their terror campaign. Why didn't John Yoo go to the Convention Against Torture, which defines torture? Why didn't he go to the U.S. report to the committee, the UN Committee Against Torture in 1999? More than that, he said that the Geneva Conventions did not apply to Al-Qaeda in Afghanistan. And he found that the common Article 3 did not apply. It's important that you stay with me on this, even if it may seem technical. Common Article 3 is common because it spreads across all of the Geneva Conventions. Common Article 3 provides that any person seized in armed conflict is entitled to humane treatment, no torture, no cruel, inhumane, and degrading treatment, and no humiliating treatment. A standard easily met by all of the list of forms of interrogation that John Yoo authorized. And Common Article 3 says that the status of such a person will be determined by the convening promptly of a competent tribunal. Why? Because sometimes innocent people get detained. And we now know that hundreds of innocent people have been detained in Guantanamo Bay. We know it because many of them have been released They've been interviewed. The McClatchy News System ran a series of articles last week. These were taxi drivers, farmers, in the wrong place at the wrong time, seized by warlords, sold for an average of $5,000 US to the Northern Alliance, transferred by the Northern Alliance to US forces, transferred through Afghanistan to Guantanamo Bay. Innocent people, as innocent, not having met all of you as you are in this audience. Innocent people. That's why you have the rule of law. Not because Dick Cheney can say that everyone in Guantanamo is the worst of the worst, but because you need to distinguish between innocent people and others, and even as to others, if you suspect them of war crimes, you bring them before a lawfully constituted court or tribunal. You do not torture them or subject them to cruel, inhumane, degrading, or humiliating treatment. And my best authority, having given this talk for 7 years, I now can invoke the United States Supreme Court. Because in 2006, in the Hamdan case, with a man alleged to be Osama bin Laden's bodyguard and driver, the U.S. Supreme Court expressly found that Common Article 3 protects Al-Qaeda, the exact proposition that John Yoo got completely wrong and launched this series of torture and abuse. And then finally in those memos, John Yoo trotted out defenses. He was writing a blueprint for CIA and other officials. It was like a consigliere writing a memo for the future conduct, to shroud it in legalisms and to protect those who were asked where and how far they could go. And John Yoo served up to them a memo that protected all of their subsequent conduct. And he even addressed defenses and offered those future war criminals the defense of necessity and the defense of self-defense. And what he didn't do, as any honest, ethical lawyer would do, is describe the fact that under the Convention of Torture, there are no such defenses. There are no exceptions that countenance torture in the Torture Convention. And so fearful of people like John Yoo, the Convention wrote into its terms that there are no such exceptions. And the official position of the U.S. government in its report to the UN Committee Against Torture in 1999 was that no official of the government, federal, state, local, civilian, or military, is authorized to commit or to instruct anyone else to commit torture, nor may any official condone or tolerate torture in any form. No exceptional circumstances may be invoked as a justification of torture. U.S. law contains no provision permitting otherwise prohibited acts of torture or other cruel, inhumane, or degrading treatment or punishment to be employed on grounds of exigent circumstances. For example, a state of public emergency or on orders from a superior officer or public authority, unquote. As recent a statement of American law and policy as 1999, it appears nowhere in John Yoo's memos, because he wasn't trying to write a fair and balanced memo to advise the President of the United States what the true limits were on detention and on executive power. His purpose was much different. It was to give cover and justification